Good morning, everyone. Thanks for being here this morning, a very special day of 4th of July. So I guess the US attendance is a little low this morning. Just a quick word to lay out this morning's program that we are so pleased to be hosting. This second Drex talk will be introduced by Alexander Fessas, Secretary General of ICC International Court of Arbitration. Thank you, Alex, for being with us this morning. The talk itself will be delivered by Emmanuel Gaillard from Sherman, Global Head of International Arbitration. The talk will be followed by a Q&A session that will be completed by 10:15. Post this talk, we'll invite you again for a networking session that should be ending around 11 o'clock. So that's the overall program that we have for this morning. Emmanuel, Alexandre, can I ask you to step in? Alex? Yeah.
Thank you, Sumit, and good morning, ladies and gentlemen. It gives me great pleasure, and I'm fully aware of the challenge that one has to face in introducing or attempting to introduce both the topic and indeed the addressee of the topic of today's DRX talk. I fear that I have attempted to capture the main takeaways of this fascinating subject from a bird's eye /or high-level point. So I hope you will forgive me if my comments and my initial thoughts on this matter seem to be mundane or not that original. Now, when one speaks of corruption, one may speak of bribery, trading in influence, abuse of functions, money laundering, and a set of other illicit activities that plague, to a certain extent, of course, international or cross-border transactions. Corruption has been defined as an act whereby something of value, usually, of course, money, is transferred to a person acting or appearing to be acting for a corporate or for a public or state entity, in order that that said recipient engage in some sort of activity or refrain from taking action that would be improper or in breach of his or her duties. Now, obviously, corruption presents significant risks for investors conducting business in nearly any and every corner of the world. It can be a universal problem, and it is a universal challenge. Transparency International recently found that over 2/3 of the 176 odd countries evaluated scored a score below 50 on a scale from 0, indicating highly corrupt, to 100, which indicates a very clean practice or activity. The global average, surprisingly, is 43% or 43, indicating endemic corruption. Furthermore, Transparency International tells us that corruption costs more than 2.6 trillion US dollars. It's about 5% of the annual global GDP, with over 1 trillion US dollars in bribes changing hands annually. The then Secretary General of the United Nations, Kofi Annan, in forwarding the UN Convention Against Corruption, which was concluded some 15 years ago, described corruption, and I quote, as an insidious plague that undermines democracy and the rule of law, leads to violations of human rights, distorts markets, erodes the quality of life, and allows organized crime, terrorism, and other threats to human security to flourish. Now, how is this all relevant in the context of our modest day-to-day practice as lawyers and arbitration practitioners? We will hear about the emergence of transnational rules very soon. primarily, however, at the outset, during the first incidents or occurrences of corruption allegation used in the context of arbitral proceedings, this matter was primarily addressed and considered a matter of domestic law. In more recent times, of course, and given the demands of cross-border trade and the prevalence of illicit practices internationally, have brought matters of corruption into the sphere of transnational rules and transnational public policy, and have prompted a number of international initiatives to take place. I mentioned the UN Convention. There are a number of other international and regional instruments that have been put in place, but of course practice as well, both soft law and other forms of practice, which I would like to touch upon in just a few minutes. So similarly, much as corruption allegations had in a first chapter of this history been the subject matter of investigation in the context of court proceedings, it was inadvertently natural that they would become more common in the context of arbitral settlement as well. One of the things that I find very curious in this debate, and I think it's very current today, is whether corruption allegations are used primarily as a shield or whether they're actually also used with some frequency also as a sword. Indeed, in most instances, such allegations are made by respondents as a means of defense against a claimant whom it accuses or they accuse of having engaged in corrupt practices. Allegations of corruption can also be made, however, by claimant parties. For instance, to support a claim that the underlying contract between parties is null and void on this account. They can also be made in relation to the procedure itself, and this is something that I think is relevant in the context of procedural decisions that arbitral tribunals may need to take in the course of a process, and indeed something that I have come to see myself while wearing this invisible institutional hat in the context of the work that arbitral institutions carry out under their institutional settings. Now, perhaps again, I'm not spilling any important beans here, but when an allegation of bribery or corruption more broadly is raised in the context of an arbitration, there are, I believe, four main considerations that become prevalent. At least that is what arbitral practice indicates to us. And conversely, arbitral tribunals are confronted with these broad four issues. First, matters of jurisdiction and or arbitrability and or admissibility. Second, how does one go about the burden of proof and the standard of proof? Third, how does an arbitrator go about a power to investigate these matters sua sponte, if at all? And finally, the obligation by the decision maker to report illicit conduct if any such obligation exists at all. Now, on all of those 4 points, and I will not go into any great detail, of course, I believe that we have come a long way, and I say this with some honesty because corruption is indeed a hot topic for good reason. I don't think it will go away, and again for good reason, but one needs to also reflect that there has been some advancement of our understanding of how those allegations can be addressed in the context of arbitral proceedings. I will only take one example, that of jurisdiction. For the longest time, it was considered that arbitration is not the appropriate forum to decide claims of corruption. The first ICC case I identified dates from the mid-1960s. It was case 1110. And now in that case, the sole arbitrator had to decide a dispute between an agent who was commissioned by a company to exert influence over members of a certain Latin American government in a bid for public procurement, for state contracts. Now, after hearing witnesses and reviewing all evidence, the sole arbitrator, and before, rather, making any decision or pronouncement on the applicable law, the sole arbitrator decided to inquire ex officio as to the validity of the contract, which again, was not a matter that was called into question by the parties themselves. Now, he did so relying on the New York Convention, and particularly Article 5.2b, and more specifically, public policy grounds, and considered that from the outset of an arbitration, arbitrators should be vested with similar powers as those of state courts in refusing a case. And again, this is not merit, this is the jurisdictional threshold, in refusing a case that risks infringing public policy. His conclusion, interestingly, was that by allying themselves with corruption, parties had indeed forfeited any right to ask for assistance from the machinery of justice, and that was the end of it. Now, obviously, that award, when it did become public, did receive a lot of attention. It was criticized, and if one contrasts it to the way that arbitral tribunals approach matters of jurisdiction and admissibility and/or admissibility today, in the context of an allegation of corrupt practice, one can see again how far that debate has gone and how nuanced and indeed varied today's approach appears to be when compared to what happened back some 50-odd years ago. The same can be said, of course, for a number of other things. Evidence, again, how does one go about burden of proof? Should there be a reversal of the burden of proof? Should the standard of proof be enforced in a rigorous and stringent manner, or should it be actually lowered? And what are the benefits under either of those scenarios, and who reaps the benefits under each respective case? The same can be said with regard to the more sensitive matter of how far an arbitral tribunal can go in investigating corruption. It is an allegation that is most frequently raised by parties, but we have seen in recent years a number of cases where the matter is on the table, or it's a big elephant in the room that nobody calls out. So in those cases, when parties do raise them, arbitrators obviously have no choice but to address the allegation. So when an arbitrator has no doubt that corruption might actually exist, and that the party harmed by the consequent illegality may not present its case properly, or a party may have an interest in not presenting its case fully in that regard, can the arbitral tribunal on its own motion realize rather act upon its own acknowledgement of the fact that the contract may have been tainted by corruption or not. And of course, this leads us to a very fundamental confrontation between basic principles of international arbitration law as we know them. On the one hand, and again, I'm drawing an example out of the ICC rules, you have an obligation that is shared between the institution and the arbitral tribunal to exert best efforts in having an award that is enforceable at law. And again, this is where we go back to Article 5 of the New York Convention in many ways. And therefore, an award that could be rendered in disregard of the possible existence of corruption may be contrary to those provisions. So how does one go about that? Those are questions, and I'm not necessarily here, thankfully, to give answers to any of them or all of them. What I would like to emphasize, however, is that there is something that is in development currently, and there is therefore something that awaits us in terms of solutions or additional ammunition in terms of consideration and tackling these points for the future. A notable initiative that recently has come to pass is a toolkit for arbitrators that has been recommended or put together by the Competence Center Arbitration and Crime at the University of Basel, which tried, perhaps in a somewhat academic manner, to summarize different points or badges or red flags that could or should raise the alert of an arbitral tribunal, either broadly in matters of corruption, more specifically in money laundering, and manners in which any of those first four facets of corruption-related matters that I mentioned earlier can be addressed. The toolkit, I think, was actually presented in Paris recently, about a month ago as well, and I believe it's freely available online if anybody wishes to consult it. In more familiar territory for me, the International Chamber of Commerce has also acted upon those things. From a very practical point of view, there are certain things certain elements in the conduct of a case that might alert either the Secretariat of the court or ultimately the court itself to raise an eyebrow and consider whether there is an element of corruption that should either be addressed with the arbitral tribunal or considered, or the implication of which should be considered in the administration of the case. Now, any of those points which I will mention may seem to be completely innocent and may actually very well be so at first glance, but if one considers them collectively and contrasts them against the background of a specific case, then obviously they may acquire a certain relevance that makes this debate all the more pertinent. For instance, are parties represented by outside counsel? Is the dispute to be heard by a sole arbitrator who has been chosen by the parties? Does the arbitration agreement itself designate eponymously who the sole arbitrator would be? Have the parties accepted fully the jurisdiction of the arbitral tribunal? Are admissions made either explicitly or potentially through the non-participation of a party and omission of the arbitral tribunal that are otherwise, in the context of adversarial proceedings, hard to digest? Have the parties agreed fully on a list of issues to be determined in the arbitration? Have the parties requested an award by consent, and when exactly have they done so? Does the arbitration agreement from the aspect of scope implicitly or expressly exclude the question of the validity of the underlying contract? And many of these issues, of course, do come up in very often, well, not very often, but they do, when they do exist, they do very often come up in the context of the review of draft awards that the ICC court conducts in the context of scrutiny. I would like to conclude by mentioning another recent initiative that I believe will hopefully cast some more beneficial light in the context of the debate that we are having today. The ICC Commission on Arbitration and ADR decided a few months ago to establish a task force that will look into the addressing of issues of corruption in international arbitration. Currently, the mandate of this task force is quite broad, which is usual, I believe, whenever a task force is going through its first steps of infancy. The scope is quite broad. The task force will have to determine definitions to be used in defining scope and in assessing whether, for instance, in addition to public and private sector corruption, other forms of illegality should also be considered in the context of international arbitration. Whether the task force will limit itself purely to commercial cases or expand its interest over into the investor-state dispute settlement cases, whether there will be talk of incidents of corruption of arbitrators or by arbitrators, although probably this will remain outside the mandate of the task force. The subject matter, of course, is to analyze, disseminate information on arbitral practice. And in doing so, obviously the task force will rely heavily on the results of all the cases that we have, most of the cases that we have administered recently that have presented any of those facets or in which corruption has manifested itself in any of those facets that I have described earlier. So there is a study of cases, not only of ICC cases, but as is usual in this context, we will be reaching out to sister arbitral institutions around the world to share their knowledge as well. The study will also hopefully provide a summary overview of substantive national laws, international law, and indeed transnational legal norms. It will identify badges, indicators, or red flags, and will work, and I think this is quite important, across a rather wide spectrum. The International Chamber of Commerce equally is active on other fields in corruption. There is a Corporate Responsibility and Anti-Corruption Commission that is looking into matters of corruption in a more broad, non-dispute-centered basis. And of course, we are joining hands with both the International Bar Association and the OECD, bodies that have actually expressed interest concurrently in looking into the subject from different angles. Those are the thoughts that I would like to share with you this morning by way of introduction to what will be a far more stimulating experience that follows in just 1 or 2 minutes. But I would not have been satisfied if I also did not mention a couple of words with regard to the person who will be addressing the emergence of transnational legal rules in the context of this subject. Now, Professor Gaillard, to start from the more mundane, is a practicing lawyer. I hope I'm not notoriously famous for calculation and math, but if I'm not mistaken, you have been practicing law for 42 odd years, more or less. Now, in the context of being a practicing lawyer, of course, Professor Gaillard has founded and heads Sherman & Sterling's international arbitration practice and is the global head of the firm's disputes unit. You may know him as a leading arbitration practitioner with vast experience in complex disputes, and that, of course, crosses the divide between commercial and investor-state cases alike. A couple of names that may sound familiar to you is Dow Chemical and Yukos. He is an expert of arbitration involving states and state-owned entities in both of those two sister fields I mentioned a minute ago. You may also have come across him in one of his other occasional pastimes, that of an arbitrator. And his resonance as a leading expert in our field is shared or rivaled by few, if any at all. In the context of today's talk, however, I would like to emphasize another facet of his activities, and that is his expertise in the field of the development of legal theory and our better understanding of arbitral practice. He has done so while at the same time tirelessly nurturing talent through various academic capacities as well, in France and beyond. So with that, I will leave you in the more able hands of Professor Gaillard. Thank you.
Thank you, Alex, for these kind words, and thank you, Accuracy and Drex, for having me presenting this important topic. Transnational answers to corruption. We know, and Alex reminded us, the staggering numbers of corruption. We are talking about 5% of the global GDP, and that's enormous, 2.3 billion yearly change hands. That's an estimate because, of course, you cannot know for sure, but that's the World Bank's estimate. So we're talking about a phenomenon which is enormous, which is a plague. Everybody agrees to that, almost everybody. I'll come back to that in a minute. And it's perfectly normal that arbitrators, being the judges of international relationships, come across corruption issues more often. So it's not, as some have said, to sort of downplay the phenomenon, a pastime or a defense or some trendy argument. It's perfectly understandable given the scope of what we are talking about, that arbitrators are increasingly confronted with these issues, which they must take very seriously. Now, there are a number of instruments to combat corruption. The first important one is the OECD Convention of 1997, which is now binding on 44 states, and possibly more importantly, it invited states to introduce in their own legislation tools to combat efficiently corruption, including corruption of foreign officials. And as you may know, this was necessary, and it has been a revolution in a number of countries, including France, because before that, corruption of legal officials was accepted and even official. You had the so-called confessionnal practice, where you had, if you were a big French company, you had to go to the Ministry of Finance and say, by the way, I bribed XYZ, and this explains my accounts. These are the numbers which I've used, so don't be surprised if I deduct from my revenues 5 million here, 5 million there, 10 million there, because it's legitimate, it's a normal deduction. It was money used to bribe XYZ. And that's the so-called confessionnal, the confession to the tax authorities, which was standard practice in France before the OECD Convention. Now, more importantly, possibly, the UN Convention Against Corruption, because it's a broader instrument, of 2003 is now binding on 186, huge success, at least in theory. So there is a broad recognition that corruption, money laundering, trading in influence has to be combated. That everybody agrees, and that's the very source of transnational answers. There is a broad consensus, and on the basis of it, broad consensus, arbitrators can derive transnationally accepted principle. And what I should say also is that it takes time for an instrument to be used. And as far as the OECD Convention is concerned, I think it became broadly effective 20 years later. 20 years later, now, we see that arbitrators start to understand the importance of the issue, and also judges in a number of countries. And you see a number of investigations in the world, Brazil, that's the Lava Jato story, which everybody knows. Italy, against big local players, ENI is a target. And these investigations have uncovered a number of corruption documents which have surfaced, and of course they end up in arbitrations as documents, because in these contracts, construction contracts, oil and gas, procurement of all kinds, you have arbitration agreements, and the judge of the validity of the contract, of its implementation, all the defenses, of course, is the arbitrator. So there, it's from these criminal investigations, you have a spillover effect before the arbitrators. So against that background, I will discuss the multiplication of arbitration proceedings involving issues of corruption. I will describe the attitude of arbitrators when confronted to corruption issues, and I will describe the attitude of judges having to deal with arbitration matters dealing with situation of corruption. First of all, the cases in which arbitrators are confronted with corruption issues are very diverse. As Alex mentioned, it covers both commercial arbitration and investment arbitration. In commercial arbitration, the issue, the first issue which is brought before arbitrators is the issue of the validity or implementation of the contract with the agent, or more generally the intermediary, taking a percentage of the contract and in charge of obtaining the contract. Generally agents, but it can be now joint venture partners or other kinds of contracts which are used sometimes to cover a channel for the payment of bribes. Because bribe takers never deal with the client directly. They use intermediaries. So you'll never have a dialogue between a minister and a client. You will always have someone coming to the client and say, I'm in very, very good terms with the minister. I can get it for you if you give me 5% of the contract price. It will be that kind of channel. And this first segment, the contract between the bribe giver and the agent, is often subject to arbitration agreements and goes to arbitration. So you have a case law which is now pretty developed on this issue. Now, there are legitimate agents, of course, who do real services, but sometimes an agent contract is just used to hide corruption. So these contracts are generally replete with good clauses saying, of course, this contract doesn't cover corruption. Of course, the money is not going to go in bad hands. Of course, that would be bad. And these arbitrators have to be very cautious with these clauses because they are there to try to legitimize the situation, and arbitrators have to look at the reality. What are their real services? There is a percentage. For what? Legitimate services or simply a conduit? And that's, they have to go beyond the words, and they do, and they have to study the reality to understand what's really going on. And this is the first case which Alex mentioned. Judge Lagergrain in '63 was the first to raise, in a situation of that kind, the fact that the contract is used to cover bribery of Argentinian officials, and that at the time he said, we cannot touch it, it's, I'm not competent. He should have said, I'm competent and it's void, but that was a first step in the right direction. Now it's completely accepted that these kind of contracts are null and void. The tribunal has jurisdiction. The fact that the contract covers corruption doesn't mean that the tribunal does not have jurisdiction. The tribunal has jurisdiction, but the contract, if it is a conduit for bribes, is null and void. And the case law is pretty consistent in this respect. Again, it doesn't mean that there are no legitimate agents. There are, but those agents are those who render real services as opposed to just channeling dirty money. Now, the question which is a bit more interesting and a bit more challenging is that of the fate, not of the contract between the bribe giver and the agent, but the contract between the bribe giver and the bribe taker, the company and the client, the substantive contract, the construction contract, the oil and gas concession, which has been obtained possibly through corruption. And here the case law is not as developed, and arbitrators are a bit reluctant at the moment to say this contract is void. Now, in theory, a contract which has been procured through corruption is void under whichever applicable law. In civil law systems, it would be void. In common law systems, it would be unenforceable, but the result is the same. The contract cannot be performed. So the contract is tainted, the substantive contract is tainted and cannot be performed. So it can be used as an excuse by a party who doesn't want to perform the contract, and it may seem unfair that a party, to arbitrators, that a party says, well, I don't perform because the contract has been procured by corrupt means, but that's the way public policy operates. So that's maybe unfair, but it's the overarching interest of society, which means that a contract of that kind is null and void. I think all the legal systems would agree more or less on this conclusion. And arbitrators have, on occasion, said that the substantive contract is null and void when it was procured through corruption. The only important example or clear example I can give of this is this rather old ICC case in a situation in which the contract, it's an oil and gas contract with an African country, it's published only in excerpts, so it's not very easy to understand, but the arbitrators understood that the contract was tainted by corruption, and they said that it was unenforceable. Now, the next question, which is the important one, and here if we are looking for transnational principles, there is an interesting debate. Once, and I think we will see more of that, and we will see cases where the oil and gas contract, the construction contract, has been procured through corruption. Then the next question, and the important one, is what happens? And here you have the traditional answer of certainly civil law countries, which is it is procured by corruption, it's null and void, but because it's immoral, then the contract, the parties stay where they are. So there is no restitution. So there is a rule following which, the traditional civil law rule, by which when a contract is procured through immoral, not illegal, immoral means, there is no restitution. So it's null and void, but you cannot say, well, okay, give me back my money, which I paid, or give me back the works. You cannot, so I want quantum merit for the works. Say, and this is a very strong anti-corruption policy. If you deal with these things, you may lose your shirt. You will not be able to get your money back if you pay it. So it's a very anti-corruption or anti-immoral contract, generally, policy. Now, recently, if we are looking for general trends, in a very controversial way, the UNIDROIT principles of 2010, the purpose of which is to find generally accepted rules, have said, well, this traditional rule is a bit too harsh, and there is a modern trend which is a more flexible approach. You look at the entirety of the circumstances and you can order some restitution. And for instance, if, for instance, the public works have been performed at 90%, and they have been paid at 50%. And the state client is saying, no, the previous government received a bribe for this contract, and therefore it's null and void. Yes, there is proof, it's null and void. Fine. What is the consequence? The old rule was you don't get the difference between the 50% payment and the 90% performance. That you can forget. You're immoral and you don't get any support from the law. That's the old rule. Now, in the more flexible, modern approach, the consequence would be, yes, it has been performed, so the contract is null and void, no future payment, but you need to compensate for what has been already done. I think it's a bad rule. I think it's a rule which does not strongly deter corruption, because at worst, if you are caught, you will get a quantum merit for what you've done. So it's not very risky to engage in those practices. I prefer personally the old rule, which is more strongly against corruption and more strongly against immoral conduct. But it would be for the applicable law to decide, or when the tribunal wants to resort to transnational principles, to say whether this new trend is the generally accepted norm, or if the old trend is still the generally accepted norm. Now, in that debate, there is an interesting decision in England, and that's Patel versus Mirza. The UK Supreme Court has itself departed from the old policy, saying no restitution, and in a very vague test, they have adopted a rule according to which it depends, there is more flexibility. You have to look at the entirety of the circumstances. So there is room for debate as to what is now the generally accepted trend, with a lot of support, not so much from the UNIDROIT principles, which were hotly debated, but from the UK Supreme Court. Now, the other type of disputes which you find is the anti-bribery clauses. In some contracts, you have a clause saying this contract has not been obtained through corrupt means, no payment, no agent was involved, and no commission was paid. And if, and that's the important part, if commissions were paid, then they have to be deducted from the price. I will give you just one example of those clauses, which is not perfectly drafted, but it's from a real case. But the key in those clauses is to have this sanction if there is an agent, if a percentage was paid to an agent, commissions were paid, they have to be deducted from the price. And that's a very important protection in procurement contracts, because it lowers the standards of what, if you are the client, you see that indeed agents were used, commissions were paid. You don't have to show corruption. Corruption is difficult to prove, so you have just to show the breach of contract. You don't have to discuss the legitimacy of the payments. It was for real services. Doesn't matter, it's a contract breach, you have the money back. And arbitrators are more and more often confronted to these questions, and they do implement these clauses, which is much easier for them. They don't have to say corruption and wonder, do I have to report anyone to the police, to the authorities? I just say there's a breach of contract. Maybe good, maybe bad, maybe legitimate, maybe illegitimate. But the parties said no agent, no commission. I ask the money to be deducted from the price as per the contract itself. So that's a very important clause. Now, in investment arbitration, arbitrators are also confronted to these issues quite often because of the legality requirement which is found in many investment protection treaties. When you have a clause of that nature, the term investment means an investment in accordance with the law of the host state. That's a simple wording. In accordance with the law of the host state, it means that the investment must be legal. And if the investment is not legal, it's not a protected investment under the treaty. Therefore, the tribunal has no jurisdiction, because the tribunal has jurisdiction only for investments within the meaning of the treaty, i.e. legal investments. So if there is corruption, the investment is not legal and it's not protected, the tribunal has no jurisdiction. So that's a very important field for debate. Now, there is a dispute as to whether, when there is no such clause, only legal investments are protected. I do not think so. I think the drafters of these treaties know what they are doing. Sometimes they say legal investments are protected. Sometimes they say all investments are protected. When they say all investments are protected, there is no jurisdiction issue, even if there is an allegation of corruption. Now, there may be a merits issue, which is different, but no jurisdiction issue in my mind, but this is disputed. Now, in implementing this type of clause, arbitrators do look at corruption issues, and they do apply. Here it's an example at Metaltech in an Uzbekistan case. They state that if there is corruption, the investment is not going to be protected. Therefore, the tribunal has no jurisdiction. Now, sometimes, and Alex mentioned that, corruption can be used as a sword as well, not just as a shield, as we have seen before. If the state is asking through its organs bribes, they say, okay, you are an investor, you are in this country, but if you want a second tranche of the works or you want this renewal of your license, of course, you have to talk to my friend and have a contract with them to channel more money. If the state is trying to take bribes, that's a violation of international law, and that in itself can be a treaty violation. That has been recognized in EDF versus Romania in particular. Now, in the face of these type of disputes, what is it that arbitrators do or should do when confronted to allegations of corruption? First, the first debate, the old debate, I would say, is that around the standard of proof. In the old way of looking at things, and here I think we see a very significant evolution. The old way of looking at corruption was to say corruption is a serious allegation, therefore the standard of proof is high, and implicitly, therefore, I don't see it, I don't want to see it. It's serious, therefore I don't see it. That was the old attitude. The subtext of when you see an award saying it's serious, therefore it demands clear and convincing evidence. It's serious, therefore the bar is high, and by the way, I don't see it because the test is not met. I don't see the money in the account of the minister. Of course, you will never see the money in the account of the minister. You will see the money in the account of the sister of the minister, having done research, market research on the feasibility of the project. That you will see, but you will not see money in the account of the minister. When you see that, it means that the subtext is, of course, there is corruption, but it's normal. In these countries, what do you expect? That's the old attitude, which still exists, and we should not accept it. the modern view is different, and that's an example of another example of the old view. I need something more likely than I need certainty, something more than likely facts, i.e. I don't want to see it. That's an old example. Now, the modern view is that expressed in, for instance, metal tech by a tribunal chaired by Gabriel Kaufmann, which to me sets the standard today. It's through inferences. The inference that inexorably emerges from this dearth of evidence is that the claimant can provide no evidence of services because no services, or at least no legitimate services at the time, were performed. So it's not like I see the account of the minister. It's like I see that there is an agent. The agent and the client is not in a position to show the services which were actually rendered for this 5%, 3%, for in this case for a few million payments, and therefore I deduct that there must be corruption. And that's the generally accepted trend. It's not like, well, it's serious, therefore there is a high burden, I don't want to see it. That's for the standard of proof. But this issue of standard of proof is really superseded by the second issue, which is that of the powers of the arbitrators. Because if the arbitrators use the powers they do have completely, they do not need to worry about the standard of proof. They have investigative powers. They can ask the parties to produce documents, and they can draw, and they should, draw adverse inferences when they don't get any answer. Give me all the alleged studies for the market study the sister of the minister has done. 2 emails? Okay. It means it's not legitimate. There is no study. It's a conduit. I deduct that from the circumstances. Or if you refuse to give me the alleged studies and all the emails which were produced in creating this study, then I draw adverse inferences. That's what arbitrators today do. And they indeed should raise sua sponte what the issue of corruption when they see it. In Metal Tech, it was interesting. It was a very, very poorly prepared witness saying in the course of the cross-examination, bragging about having been very efficient and paying monies to obtain the contract. You know, the guy was very proud to say, I did a great job for the company. I obtained these contracts. So everybody was shocked. And the tribunal said, hey, what's going on? Show me what was the services performed for these payments. And the tribunal raised the issue sua sponte, used the powers they have. This is a very good example of the proper attitude. Use their investigative powers, deducted from the result or lack of result that it was an illegitimate payment. Therefore, they have, as we have seen, no jurisdiction on the matter. Now, the last important methodology issue is that arbitrators now are using circumstantial evidence, or the red flag methodology, as opposed to direct evidence of a payment to a public official. It's this methodology which the OECD has always advocated, which is used both in ICC arbitration in commercial matters, all these indications, presumptions, indication, percentage, excessive level of remuneration, the corruption environment, the repeat nature of the corrupt practices from the company, all of that are, and of course the inability to prove real activity, all of that are red flags which put together become circumstantial evidence. in the context of investment arbitration, this methodology is also followed, as we see in the Spentex matter against Uzbekistan. That's a repeat client for these issues, apparently. And here you have a tribunal saying we use these red flags to conclude that there is corruption and therefore no protection from the treaty. And here you see that the old way of looking at things has not completely disappeared, because in this case, for example, which is a recent one, you see that the tribunal is requiring more than red flags and a high level of evidence to decide that there is corruption. And here you see that they say the legal burden of proving corruption rests upon the party alleging corruption, and it is not discharged by placing the burden on the adverse party to prove the absence of corruption. That's the old view. It's an important allegation. Therefore, several were classic red flags, the tribunal says, but even the reddest of red flags does not suffice without proof of corruption before the tribunal. And that's the old view, which is not completely dispelled. And here there is a dissent from one of the arbitrators. But when this attitude is followed, the courts are here to say, well, this is not right. And I will say now a few words as to the attitude of courts in this respect, because the courts in a number of jurisdictions have clearly said, arbitrators, you have to do your job. You have an important job. You are the judges of international matters, but you have to enforce public policy requirements, and you have to be careful, and you have to really sanction corruption when you see it. The courts themselves have evolved, and you see, if you look at an old French case, you see evidence of the old attitude. This is in European gas turbine, a case of an old case, I cannot see from this slide, which says what some arbitrators used to say, I need to infer with certainty the existence of corruption. And therefore I don't see corruption, even if in this case today they would have seen corruption in my view. Now, recently, as recently as 2017, the French courts have reversed this view. They have said now arbitrators have to enforce corruption issues. When they see corruption, they have to say it. And here, this was an English case where, for procedural reasons, the arbitrator, because security for claim was not posted, said, well, for technical reasons, you lose, I don't look at the merits. The French court said, no, you have to look at the merits if there is a public policy issue involved. And the important case is Bellocon. In Bellocon, the tribunal, following the old approach, and that was a very reputable tribunal chaired by Jan Paulson, the tribunal said basically, I don't have decisive evidence. And I'm a tribunal. In the country itself, there is an investigation, The investigation was not conclusive, and if the state cannot see corruption through the public prosecution, I cannot see it either. Now, the French court said, no, you have to look at all the elements. It was not corruption, it was money laundering, but it's the same methodology. This is an international public order question. It does not require a local conviction. And the OECD here would say you're absolutely right, because the OECD always said the state is often part of the problem. It's not part of the solution. They don't want to see corruption. And because the state may be corrupt, we had the stats of Amnesty International. And it's not for the state necessarily alone to police this. Arbitrators should police it. And it doesn't require proof, or certainly not a prerequisite of criminal investigation, conviction. We are talking about a civil standard of proof, not a criminal standard of proof. And the test the French law has derived is that any award which allows a party to benefit from the proceeds, it's a very concrete test, to allow a party to benefit from the proceeds of criminal activities is against the French understanding of international public policy, as evidenced by the New York Convention, which we have seen before. So the test is very clear, and the key is that the red flag methodology, the key element in this case law, is that French courts invite arbitrators to use the red flag methodology. They say you have to look at serious, precise, and consistent evidence that there is corruption, money laundering, or something of that kind, an illegality in the international sense. Des indices sérieux, précis et concordants. Serious, precise, and consistent elements would be a better translation of the test. So it's really the red flag methodology. French courts have used this red flag methodology very aggressively recently. In a case, a very interesting case, Alstom Transport versus an agent, Alstom was dancing around the issue. They didn't want to pay the part of the price they promised to the agent if they were able to secure the contract, which they have. And they were saying, well, there is a violation of a contractual provision according to which they have to give us the accounts, they have to show their accounting, therefore this was not enforced properly by the arbitrators, it's fishy, and therefore you should annul the award. The Court of Appeal reopened the debate and said, you, Alstom, have to choose. Either you say there is corruption or you don't. If you say there is a violation of the contract, it's not my problem, it's merits, and I don't review it. If you say there is corruption, you have to call it corruption, and I will look into it. So you decide what you want to argue. So they reopened the debate and said to Alstom, you cannot, I don't care about contract violations, I care about international public policy. Corruption is part of that. The contract is merits, not my problem. You decide. Alstom decided to plead guilty in a way and say, yes, there is corruption. Yes, I call it corruption. And there is corruption. Look into it. And the tribunal, a month ago, the Court of Appeals, used its own Bellocon test, its own red flag methodology test, saying there, in this case, I find serious, precise, and converging indicia, elements, des indices sérieux, précis, et concordants, that there is corruption. And among these, they identified two elements which they find particularly important, which are the fact that the agent gave advance notice that the company Alstom was winning the bid before it was publicly announced. So that is a strong indication of something fishy. The fact that they had information about the other bidders, the fact that they had no evidence of real legitimate activity for the percentage they were getting. All of that taken together is circumstantial evidence. That's the way the red flag methodology works, and can amount to, or the circumstantial evidence as opposed to high evidence, really direct evidence of a payment to a public official is working. So that's the way they use it. And from a legal standpoint, and that's my last remark, it's quite interesting the balance French courts are striking. They say, I care about corruption, this is international public policy. I don't care about the contracts, even the contract mechanisms, that's for the arbitrators to, it's still important, as I said before, but it's for the arbitrators to implement. That's a contract issue, merits, not my problem. At the same time, if in the country in question, there is a rule saying you have to have public procurement, for instance, the violation of such rule, which is a loi de police, does not concern me. So that's, from an intellectual or academic standpoint, it's very interesting because it's the French court saying, I don't care about foreign loi de police, I care about the violation of transnational public policy. The laws of the PRC may have been violated in this case, may not. I don't care, it's not my problem. I'm not here to enforce the laws of the PRC, just in the same way I'm not here to enforce the contract. I'm here to enforce the public policy requirements. Now, that said, the fact that the laws of the client may have been violated is one of the red flags which can be used in the red flag methodology to show corruption, because that's a red flag, that's a problem if the local requirements have not been fulfilled, just like any other indication of corruption. That's an indication of corruption. That's an indice, but alone it's not enough. I'm not here to sanction foreign loi de police. I'm here to sanction international, even transnational public policy. And that's a clear message sent to arbitrators. They have to take corruption seriously, more seriously than some have done in the past, still sometimes do today. Corruption is a plague, and arbitrators have to take it seriously. They have, through a red flag methodology, see corruption when they are confronted with serious indication that corruption exists, and that's the current transnational response to corruption in international arbitration. Thank you very much for your patience.
Thank you very much, Manuel. I don't know if I'm the one who should trigger the Q&A. I do have one question, which may prompt a long answer, so please feel free to answer it the way you best see fit. Yes, I'm fascinated by the procedural aspect of this, and what you, when you were raising in your first remark with regard to agency agreements, you said arbitrators have to go beyond the word of the contract. And I would like to have your views on that in this instance where no party is actually making the corruption allegation or the an allegation of bribery. And whether in those instances your sense is that arbitrators will only not go there because they think, well, that's the standard practice in that neck of the woods, or is it sometimes also because of political sensitivities or undue pressure that they may then, or criticism that they may then be exposed to if they go down that route. And I'm thinking of two examples. First, let's assume an arrangement, let's call it an agency agreement, where there is an individual who has been promised consideration if he introduces the prospective contractor to certain ties that can procure him a certain contract, and then claims that money without the service ever having been proven. And the second, where an arbitral tribunal may consider that ahead of a hearing, the parties have not actually proposed the witnesses that are pertinent in its ascertaining of what had happened. What are your thoughts on perhaps those two issues?
The answer is yes. Short. Arbitrators, well, I think the deterrents for arbitrators are twofold. Some think that it's normal, that's normal practice. I think that trend is really fading away. But another problem is a deterrent to raising or finding corruption is that they don't know if they have to report the events. If I say there is corruption, then maybe I have to report, maybe I have money laundering rules applying to me, those of the seat maybe, those of my nationality, those of the applicable law, transnational principles, who knows, but maybe I have to do something with it, and that's a bit embarrassing. I think arbitrators should disregard that. They are private judges. They should find corruption when they see it. Certainly, it's accepted that they can raise it sua sponte when they see it's one of your questions. It has not been raised by the parties. They can raise it and should raise it. Now, they should be curious. They should use the investigative powers they have. And I think now the trend is really to use it. So you say there is an agent. You say it's legitimate activities. And yes, there are lots of agents which are legitimate, by the way. It's certainly possible to say, I give you a commission, even a percentage, to promote my products in this country. That's perfectly fine, but it takes a real promotion activity and not just being a conduit, right? So the investigative powers of the tribunal are, what have you done for this money? And today, you must have emails. If you have done real activity, you must have a track of that. So give me all of your emails dealing with the promotion campaign, with the market study, whatever a consultant would do. That's perfectly fine. So the last element, which is interesting and which is in the mix, is the issue of influence peddling, because in some countries it's criminalized, in others it is not, and you need to show real corruption and just not influence peddling. And the beauty of influence peddling is that it can be just an attempt of influence peddling. It can be, I know the minister, give me 5%, I will get you the contract. And even if the person doesn't know the minister and has not obtained the contract, it's pure posturing, it's pure extortion. If it is criminalized as such, it would be a sanction under the applicable law. And as far as international law is concerned, it's certainly an element of impropriety. So that's a long-winded answer for a very difficult question.
Thank you very much. Should we open it to the floor? I see you didn't need much encouragement. Good.
Thank you. With regard to consequences of corruption, you mentioned that the new rule of full restitution isn't really fit for purpose as a deterrent of corruption. Now, if the proportional rule approach is adopted, as was vaguely proposed by the Mirza and Patel case in the UK. Don't you think that in the absence of any rigor test, this will only open the floodgate of inconsistency in the arbitral practice, and that would render impossible the emergence of any transnational response whatsoever on the matter? And if so, do you think whether and how the transnational response will emerge, or we will stay with the existing dichotomy of full or no restitution, depending on the jurisdiction?
Would you rather we take all questions at the same time, or to avoid the to and fro?
Maybe I just answer. This is a specific question. Okay. The answer is that it is. I don't like the Unidroit answer personally, but that's my own, personal view. Now, I recognize that there is room for discussion as to what is, if you are applying a transnational response, there is room for discussion as to what it is today, but it's possible that one could argue that the transnationally accepted response today, because of Unidroit, it's a bit because of the UK, is a flexible test, taking into account, and that's the Patel answer, taking into account all the circumstances of the case. So that's a different policy, a policy saying you take into account the circumstances of the case, and I give you, judge, a lot of flexibility. I prefer the old approach, which is you deal with immoral conduct, you take your chances, because if you pay something, you may never see it back, even if the other side is a crook and takes the money and run, right? So I sort of like the old policy. I'm old-fashioned, maybe, after having practiced the law for more years than you want to count. But I can accept that maybe the new trend will be, it depends on the circumstances. But certainly, the lobby of bribe givers has been operating, because they certainly much prefer the new rule, which is, well, if I have performed 90% of the contract, I want a quantum merit for 90% in any event, even if the contract is set aside and I cannot get the full performance of the contract. I need the flexibility to claim a quantum merit payment. So, but the jury is out as to what, and that's how transnational rules are produced. You have discussion at the international level, and to me this is one of the only open questions today as to where we stand exactly.
Well, so I will see the issue of that conference with another side angle, which is the one of the third-party funding. I'm representing proper investment, regulated. And our experience over 10 years is that corruption as such is something which is solid and, where both parties are solidar. We are here addressing points where maybe less than 10% of the cases where one party is challenging the other one because of corruption. But most of the time there is a corruptor, a briber, a bribed, and they are keeping silent about corruption. And this means that arbitral tribunals are then dealing with cases remaining blind about the probable corruption or behind the curtail, because it is not at all addressed by the parties. And so the point I wanted to make is that our view is that choosing third-party funding as a regulated, fully regulated activity, and the external control of supervisors compels to make due diligence about, naturally, the origin of the financial means, but also about the morality of the cases, so that we really protect the reputation of the investors and of the case. And we are using the red flag methodology, but then in a much larger scale than was addressed here. We will then tend to make due diligence with a red flag methodology about the case, the emergence of the dispute, about the parties, and especially the funded party, etc. And it can be, part of the moves that you described, Professor Gaillard, very well, that from the traditional principles up to the, view of the current views of the tribunals, institutions, etc., making maybe more difficult and the access to arbitration of pathological cases where the corruption will not be addressed by one of the parties, but anyway be part of the issue.
Should we take the question in the back as well, please?
Yes, Professor Gaillard, you said that even if the parties do not raise the issue of corruption, if the arbitrators have suspicion that arbitration does exist, the arbitrators should raise the issue. So what does it happen if the arbitrators come to the conclusion that arbitration does exist? Can they or should they declare the contract null and void, even if no party asks for that? Is it possible? Or should do that? Should they do that?
So TPF as an enabler of due diligence enabler and therefore risk aversion for corruption, and nullity and avoidance of contract as a result of the tribunal poking into where the parties doesn't want it to poke.
The TPF question is, both questions are interesting, and the TPF question raises the issue of the distinction between the red flag methodology in the context of an audit. You have to know your client, do you want to deal with this company, and here you have a red flag methodology which can be loose, can be, oh, there are enough red flags, I don't want to deal with this partner, I don't want to buy this company, I don't want to fund it. This is different, and that's a good opportunity to distinguish the two from the red flag methodology, for lack of a better word in English, for the methodology of circumstantial evidence through indice grave, précis et concordant, which is a bit more. It's not just, I have enough, it smells, I don't want to deal with this person. There is enough to conclude through this impressionistic methodology that there is corruption. So it's still evidence, as opposed to enough evidence not to have to deal with them, and it's different. So there are two red flag methodologies. This term is imprecise. The I don't want to deal with you, and the I have seen enough of these elements, circumstantial evidence, these different elements which taken together amount to a real proof. So that's, but you're right, third-party funders, like everyone else, should do a methodology following the first use of the red flag methodology, but both cannot be confused. Now, as to the difficult question of what arbitrators should do when they see something which raises concerns, and arbitration, yes, can be used for money laundering purposes. we can concoct an agreement, a person to which you sue me and I lose, and I have created an award against me to transfer money to you with a legitimate title. That happens. It's not just corruption, it's also money laundering, which is a concern, and institutions and third-party funders and all the players, certainly arbitrators, should be concerned with that. I don't want to be manipulated and instrumentalized as a conduit to create a title which is just meant for money laundering. So if you see something of that kind as an arbitrator, I think it's pretty much accepted that you can and should raise the issue sua sponte. Then even if the parties, when you raise the issue, say, no, there is no problem at all, but you see a problem, you can investigate, you can ask them document production sua sponte, because it's public policy, so it's not a breach of your mandate. That's implicit in your question. It's not a breach of the mandate, even if no party raised it, because it's your mandate from the public policy requirement to raise that question. So show me, depending what it is, you say that you owe them money because in a suspected money laundering situation, because of, and if you are too inquisitive, they will pull the plug. It has happened before. Say, okay, we waive this, we terminate the contract. Now, if you really see that the parties are playing games, they are not giving you satisfactory evidence, you can, it would be very gutsy, you can and probably should say that the contract is void. A lager green type answer would be to resign or to not be involved in that. But if you raise sufficient number of questions, the parties will start, if complying or pulling the plug. They may not want to, but certainly an arbitrator convinced that there is something wrong should not proceed and ignore the problem, I think. Because again, we will see more of that in the future. It's an ideal money laundering conduit. If you concoct a false defense and, okay, I lose, too bad, I give you 100 million, no problem, and then you can enforce it against me. That's a dangerous situation for arbitrators and for the institutions and for everybody.
Thank you. On the due diligence enabling side of TPF, I think the other distinction that could perhaps be made is that obviously corruption does not get born in the context of the arbitration. And in that sense, there is much more that can be done and is actually now being done more than before in enabling policies within corporate groups, but also, and this is quite interesting, at the level of small and medium enterprises, in ensuring that there is due diligence and there are checklists and guidelines and clear policies with regard to matters of corruption. And I think that's where the anti-bribery clause also becomes very handy ultimately. And on the second point, the second question, and with regard to the tribunal doing or not doing something, I think the limit of that, and in a way the more clear manifestation of that, is when a tribunal is actually asked to render an award by consent. And there, much as it's not discretionary in the sense that they're not exercising inquisitorial powers, they are actually exercising discretion in rendering an award or not doing so in circumstances where they may or may not be fully aware of the contents of the parties' settlement arrangements. And that is where we have actually seen arbitrators, contrary to the 1963 award, instead of saying, no jurisdiction, basically saying, I will not render this award by consent, and then miraculously the parties disappearing. I know that we are a little bit pressed for time. I can see Sumit is already standing, but we can go to Shashank and maybe one more question, if both are questions and not comments. Thank you.
Thank you. Just to follow up a question on what has been asked. Given the fact that tribunal is considered the master of evidence, in fact, in the light of this, what happens if first time the allegations of corruption or bribery are taken up during setting aside proceedings or execution, and they were never taken before the tribunal, and tribunal never had any inkling of any corruption being involved? How do national courts in your experience, deal with a situation like that?
Good morning, thank you. Professor Gaillard, you talked about the attitude of national courts regarding the issue of corruption in international arbitration. What is interesting also to tackle, I think, is the position of the national authorities and criminal bodies in respect to this matter, and notably the matter of cooperation, maybe, I would not say concretely between the arbitral tribunal, but maybe arbitral institutions, and whether and in which manner have you had the experience of criminal bodies in different states involving themselves after finding out of issues related to corruption in international arbitrations? Thank you.
Okay, my question is regarding, is from the point of view of the parties. You said that this allegation of corruption can be used both as a sword and a shield. So I want to know, what are the defenses that the other party can use to stop a party from bringing up this allegation of corruption?
Anthony Theolorant, Accuracy. Some of the red flags you mentioned seemed to me of an economic nature, and I was wondering to what extent us as financial experts should be looking into those matters and those red flags, whether in assessing damages or where some allegations of corruptions are made.
To start with the last question, yes. I mean, this is the legality of the business is part of its value, and that's a methodology which is proper to use when assessing the value of a business. If the business is corrupt, its value may be hindered. So it's not just like you look at the flow of revenues, you look at the sources of those revenues. So that's a legitimate methodology to use in that context. As to the first question was, so your question was the courts, when nothing has been argued before the arbitral tribunal, can you raise it before the courts? I guess the answer would be given by the law of each legal system, but generally being an issue of public policy, it would be possible. And the French answer to that is very clear. It's yes. It doesn't matter. You can use elements to show that the underlying contract is obtained through corruption, and the test being, I don't want to let an award which gives a party the benefit of their illegal activity, so I can set aside an award even if nothing was presented to the arbitrators, i.e. even if it's not the arbitrator's fault. But I have now new evidence, because there is an ongoing criminal investigation, for instance, new evidence has surfaced, so I will still, French judge, I will still set aside the award if that surfaces. The Swiss judge would say I would still do that even long after the fact. If there is new evidence, I can revise the award. I can even disregard the statute of limitation and to set aside the award if I see new evidence arising from criminal investigation. So that, and maybe the other is an institution, and you can answer that.
I think we both could, but yes, sure, of course. If I understood the question correctly, at least, yes. I mean, when it's used more as a sword and it's for the purposes of pursuing a claim, then the defense of that would be I mean, if the allegation, if the basis is I am disengaging because your conduct has actually created damage to the company, and therefore this leads to either breach of the contract or ultimately, for any other reason, contractual, non-contractual termination and restitution or otherwise damages, then obviously the defenses there, I think, are a little bit more, I wouldn't say standard, but you can think of what those defenses would be. So I think the difference is that when it's used as a sword, it's very present in the case. It's there, and it's usually, in my experience at least, the result of a shift in corporate philosophy. So there is a change that has been prompted in the activities of the company, either because of recent experiences in the context of corruption allegations, or a very rigorous strengthening of its anti-corruption policies, which prompts it to then revise basically its arrangements with different parties.
Maybe a last word on the defenses. Because I talk about transnational trends, I'm not suggesting that you don't look, when the parties have selected an applicable law, you don't look at the applicable law. So the applicable law will give you all the rules, all the defenses, statute of limitation, possibly if it's a substantive issue, or which it is, or all the kinds of defenses, contractual defenses which you find in the applicable law. So the transnational response would be directly applicable in two situations. One, when the parties have said that general principles apply, which is sometimes the case, or even when there is a law chosen, when you are at the level of a violation of a transnational public policy, and corruption certainly is one. So even if the law of a given country has been selected, arbitrators, in my view, should make sure that transnational public policy, including the combat against corruption, is respected. But again, most of the answer to your question would be found in the applicable law.
Right. Thank you very much, Emmanuel. Thank you very much, Alex. Just before calling a last round of applause, some logistic details. This talk will be made available on Drex website from tomorrow, if I'm not mistaken. We are super proud to have hosted the second talk after Delhi. I think we've set the standard pretty high in Paris. Just a brief teaser on the upcoming talks. It's summertime, so I'll give you some food for thought in terms of travel plans that you might be considering. Next set of talks is aligned, starting with Mauritius, if I'm not mistaken, London, and then Dubai, as far as I know. Just before thanking again Emmanuel and Alex, I'd like to include Shashank also, who's come from Delhi actually to attend this talk. Shashank was instrumental in conceptualizing the Drex concept itself. Once again, thank you all of you for being with us this morning.